For the introduction, in Malaysia, an order for security for cause is a legal mechanism available under Order 23 of the ROC 2012. This order allows a defendant to request the court to require the plaintiff to provide security for the defendant legal cause before the case proceeds. The purpose of the order is to protect defendant from potential financial loss if they successfully defend a claim but are unable to recover their legal costs from the plaintiff. It also acts as a safeguard against situation where the plaintiff lacks sufficient funds or asset to cover the defendant's costs in the event the plaintiff lose the case. To obtain an order for security or for cause, the order or the defendant must demonstrate to the court there are reasonable grounds or reason to believe that the plaintiff may be unable to pay the defendant costs if the defendant is successful in the litigation. The court will consider various factors such as the financial status of the plaintiff, whether the plaintiff is a nominal plaintiff or has a good arguable case, and any other relevant circumstances. And failure by the plaintiff to comply with the order for security for cause may result in the dismissal of the plaintiff claim or other adverse consequences imposed by the court.
I'm Shamika Siraja, matrix number 272866. So today I will be presenting and discussing about the circumstances or the grounds for making an application for security for cause under Order 23 Rules of Court 2012. So firstly, let's look at the very first ground or very first circumstances provided by Order 23 Rule 1A of Rules of Court 2012. Firstly, the plaintiff is ordinarily resident out of jurisdiction. As what can be seen in this slide, there are three cases that has been listed down. Firstly, Kasturi Palm Products, SNS Power Switch Gear Limited, and Aerorev Spa. Basically, in all these three cases, what the court held was security for cause will not be awarded as of right against a company that is resident out of the jurisdiction. So basically, in all these three cases, this one thing was finalized by the court. However, in the case of Sonic Finance, the court actually ruled in defendant's favor by asking plaintiff to pay for security for cause, and there was a counterclaim by the defendant. So we can see there's some kind of difference from what was held by the court in this case compared to the previous three cases that was discussed. So the principles that was involved in this case was firstly, the plaintiffs are foreign companies within the meaning of Sub-Rule 1A, as what we have discussed just now. Secondly, the plaintiffs have no known assets within the jurisdiction of this court, and their financial positions are also uncertain and questionable. And finally, there are no reciprocal arrangements between Malaysia and Republic of Marshall Islands on the enforcement of judgments and orders. However, in this case, although the defendant succeeded, what the court did was the court awarded a lower amount to what the defendant prayed for. The second circumstance provided by Rules of Court under Order 23 Rule 1B is plaintiff is normal plaintiff suing for benefit of some other person, and there is reason to believe that he will be unable to pay the cost of defendant. So this is the second circumstance. So now we will move on to the third and the fourth. Thank you.
Hello, my name is Rashami Izzati binti Yusof. My metric number is 273743. So, next, the third circumstance provided under Order 22 Rule 1 Sub-Rule 1C stipulates that the court shall consider granting security for cause to the defendant if the plaintiff failed to state its address or had incorrectly stated its address in a writ or an originating summon. This actually can be seen in the case of Kuh Chung Wui and another's against Time Darby Ara Damansara Development Sdn Berhad, whereby in this case, it involved an application by the defendant for security for cause to be paid by the first and the second plaintiff based on this order, whereby the defendant requests the security for cause due to the discrepancy in the plaintiff addresses and doubt about their ability to pay costs if the defendant succeed. The court held that the first plaintiff failed to provide sufficient evidence regarding his addresses, and the address in the National Registration Department records is considered as a current one. Similarly, the second plaintiff did not also explain the discrepancy in addresses and failed to update his address with the National Registration Department. Consequently, the defendant application for security for cause is granted. However, the circumstance of misstating addresses in read or originating summon is subjected to Order 23 Rule 1 Sub Rule 2, whereby the court shall not require the plaintiff to give security for cause if the misstatement was innocently done without any intention to deceive. This is actually an exception to the circumstance which the court will consider. This exception has been clearly explained in the case of Rusdi Kirana against Chia Kunti, whereby in this case the court discussed about this order rule 1 sub rule 2 has provides the opportunity to the plaintiff to explain to the court that the omission to state the address in read was done innocently and without an intention to deceive. The court also highlight that overlooking this provision and giving no explanation therefore must necessarily mean that the omission was deliberate, and the action of misstatement and omission to state the address is not innocently done subsequently to find that the defendant has made out a case for requiring security for cause. Thank you.
Hi, I'm Shamra Shankar and I'm going to present on the order of 23 Rule 1D of Rules of Court 2012, which provides for changing and or withholding one's address. The defendant may take advantage of this information and utilize it in its application for security if during the course of litigation the plaintiff changes its address or declines to reveal it. The justification for this is that the plaintiff want to hide its assets and prevent their discovery and thereby evading the consequences of litigation. In Luminous Crossroads Sunyanberhat versus Lim Kong Huat Construction, the Lordship's Low Hobbing judge held that plaintiff's conduct in altering its address were plainly intended to dodge the consequences of litigation. The plaintiff was thus forced to provide for cost. Moving to the next element, which is discretion of court to grant security of cost. The court has discretion in this instance regarding security for cost. The court summarized its deliberation in Luminous Crossroads Sunyanberhat versus Lim Kong Huat Construction by using the ratio in Sir Lindsay Parkinson versus Triplan Limited to exercise this discretion. It is a tried law that under Order 23 and Section 351, the court has a discretion which must be exercised after considering all the circumstances of the particular case. In addition to this, discretion is a judicial discretion which must be exercised according to established judicial principles. In Salchi Spa versus Le Chung Chai, the court's rationale in balancing the justice of granting an application for security of cost lies in the surrounding situation of a given case. Whilst the circumstances that the court ought to consider might vary from case to case, it would be impossible to categorize such circumstances. It is here that the court exercises its discretion by weighing the circumstances emanating from each case and to consider whether the justice of the case requires the granting of such security for cost. To conclude, the court will consider the specific circumstances of the case, including the parties' financial positions, the merits of the case, and any potential prejudice that may arise from granting or denying the application. Thank you. That's all from me.
Assalamualaikum, my name is Putri Nabila Huda, BT Maisa, match number 273825. So today I'm going to present about security for cost. Under Order 3 of Court 2012, the counterparty is a company or individual that is not resident in Malaysia and has no assets within the jurisdiction of Malaysia. The financial position of the counterparty is such that it would be impossible to recover legal costs even if party is successful in defending the claim in the court. The plaintiff address for service is intentionally not stated or misleading, and the plaintiff has changed his address in the course of proceeding to evade the consequence of litigation. Next, for security for cost, illegal proceedings should not hinder access to justice, which is a fundamental guarantee under the Federal Constitution. The court's purpose is to ensure a fair hearing for all parties involved without creating obstacles like security for cost. This is especially important for individuals or companies who are poor, needy, or oppressed. The decision on security for cost should not be arbitrary and solely based on case law, but should take into account the litigant's ability to pay. Considering the litigant's means of payment is crucial within the framework of the Federal Constitution, as it guarantees access to justice. The acts such as CGA 1964 and rules of court are designed to facilitate this entrenched right.
Hi, my name is Nusaranda Binti Syafiq Ahmad, metric number 273808, and I'm going to present about the cases. So in the first case, we have Tan Hui Tin against Tam Yi An, where in this case, the first plaintiff applied for security of cost, which was granted by the court. The court wrote that the plaintiff's application was not intended to deny the second and third defendant to a fair trial, but rather to protect the plaintiff's interest in the case of defendants fail in their counterclaim. The court stated that the plaintiff should not be put under hardship trying to recover costs from the defendants at a later stage. Next, we have a case of Raju Rajaram, where in this case, the plaintiff is a company residing in Madras, State of India, and defendant is a Malaysian company. Cause of action is breach of contract. So the principle laid out in this case is, plaintiff is ordinarily resident out from the jurisdiction of Malaysia. Second, the plaintiff had no assets in Malaysia. And third, Madras was excluded from the first schedule of the Reciprocal Enforcement of the Judgment Act 1958. And this event, the plaintiff were to lose his case, because no impediment for the plaintiff to move to the Madras from the Bombay, or for that matter to any other excluded state in the India to evade paying costs. There was no necessity at all at this juncture to go into a minute and in-depth detail of the merits of the case. Whereas in the last case, we have Tristan Madison Lee. Chua Keng Long, the plaintiff in the case, are American citizen holding USA passport and residing at the first plaintiff's father house in Kota Kinabalu. The defendant is a Canadian citizen. One of the principles that the court must consider is the likelihood of the success for both of the plaintiff and the defendant in the action. It has been established that discussing the merits of the case should not be done at this stage of the proceedings.
And for the conclusion, it is important to note that the specific circumstances and procedures for making an application for security for cost may vary depending on the court's discretion and the specific fact of the case. To ensure accurate and up-to-date information, it is advisable to consult with a qualified legal professional or practitioner, or refer to the latest version of the rule of court in Malaysia.